the director of the Humanities Center. I'm delighted to see so many of you here to listen to this important topic, litigation on the opioid crisis, to be given by an expert in the field, Professor Lance Gable. Professor Lance Gable is an associate professor of law at Wayne State University, where he teaches courses on public health law, bioethics and the law, torts and other health law subjects. He's been a member of the law school faculty since 2006. From 2013 to 2014, he served as interim associate dean of the school, then became the associate dean in 2014, and then appointed interim dean from 2016 to 2017. Professor Gable holds a Bachelor of Arts degree in Political Science from Johns Hopkins University and a Master of Public Health from Johns Hopkins Bloomington School of Public Health. He earned his law degree from Georgetown University Law Center. He is an internationally known expert on public health law and bioethics. His research addresses the overlapping among law, policy, ethics, health, and science. He has published journal articles in a diverse array of topics, including public health law, ethics and policy, international human rights, bioterrorism and emergency preparedness, mental health, research ethics, and information privacy. He is co-editor or co-author, respectively, of two books, Research with High-Risk Populations, Balancing Science, Ethics, and the Law, and Legal Aspects of HIV/AIDS, a guide to policy and law reform. In recognition of his interdisciplinary scholarship, he became the recipient of the 2010 Wayne State University Academy of Scholars Junior Faculty Award for the Humanities and Social Sciences. Professor Gable has helped the Michigan Department of Health and Human Services develop ethical guidelines for the allocation of scarce medical resources during public health emergencies. He's also assisted with the development of course materials for the World Health Organization Diploma in International Human Rights and Mental Health, and has worked as a human rights consultant for the Pan American Health Organization. He has served as co-chair of Wayne State University's Stem Cell Research Oversight Committee, co-chair of the university's Clinical and Transnational Research Ethics Workshop. Prior to joining the Wayne Law faculty, Professor Gable was a senior fellow at the Centers for Law and Public Health, a collaborative at Georgetown and Johns Hopkins Universities affiliated with the World Health Organization and U.S. Centers for Disease Control and Prevention. He continued this affiliation with the centers as a scholar from 2006 to 2012. He previously was project director for the Emergency System for Advanced Registration for Voluntary Health Professionals Legal and Regulatory Issues Project, administered by the Health Resources and Services Administration. He was also the Alfred P. Sloan Fellow in Bioterrorism Law and Policy at the Centers for Law and Public Health, and participated as a healthcare law attorney at a major international firm in Washington, D.C. I'll stop there, but I think you get the idea that you're in the presence of a very busy, very engaged scholar who is passionate about this subject, and that you are very lucky to have him come and talk to you today. But before I let him begin his talk, I want to express my gratitude to him for his involvement in the Humanities Center's work. He is frequently here at our Brownback Talks, and he himself has given several Brownback Talks in the past. Last year, he gave a talk here entitled Criticized, Fired, Sued, and Prosecuted, Hindsight and Public Health Accountability. In 2012, as an assistant professor, he gave a talk entitled Health Reform, Public Health and the Elusive Target of Human Rights. And in 2011, as an assistant professor, he gave a talk on ethical allocation of scarce medical resources during public health emergencies. So please welcome to the podium Professor Lance Gilbert.
Thank you, Walter. That was much more of an introduction than I expected, and you know, I appreciate being back here again. It's been great to have the chance a number of times over the years to come and talk to these lunch brown bags. And my topic today is a little bit different than some of the ones I've presented on in the past. It's comes out of some recent work I've been doing, looking at how litigation has the potential to shape both what has already occurred related to the opioid crisis and what will occur in the future. And I'm going to focus, I mean, there are a lot of different ways to approach this topic. I am going to spend probably the first 10-15 minutes or so talking about some of the background of the opioid crisis itself, and also some of the regulatory background that kind of puts us to where we are right now. And then I'm going to spend the remaining time talking about what's going on in efforts, litigation efforts, to try to hold accountable some of the companies and other people who were involved in the, at least in some of the factors that led to increase in opioid overdoses that have really spiked to an extremely high level in the past decade or so. Also offer a bit of a critique of using litigation as a strategy to try to resolve these kinds of problems, because while litigation has its role in our system and can be very important in holding people accountable, it also is limited in what it can really accomplish. And if we're really intent on having a public health focused strategy to try to overcome some of the harms that are being caused by opioid overdoses, we really need to think very broadly and not expect that litigation is going to solve the problem. So I guess I'm going to try to approach this by pulling together kind of 6 separate themes or ideas, and they're listed here on the slide. So and all of these things help explain either the background or the current context of what's going on related to litigation that's connected to the opioid crisis. And so we'll start talking a little bit about the history of how law and legal regulation have controlled access to pharmaceuticals and use of pharmaceutical products, and then also as well regulation of pain treatment and how that plays into the story. We'll talk about how changes in the way that medications are marketed also contributed to this situation, and also are the basis of a lot of the ongoing litigation, at least litigation against the manufacturers of these medications. We'll talk about the effects that some of these trends have had on opioid dependency and overuse. We'll also talk about how some past efforts to use litigation to hold industries accountable, in particular tobacco litigation, kind of sets the stage for what's currently going on, and actually is a bit of a cautionary tale in some ways. And finally, we'll talk about how attempts to use preemption and privatization, and then those debates that go on about when it's appropriate to privatize certain legal services, when it's appropriate to prevent lower level governments from going forward, are now transferring into the litigation space when we used to see them mostly in debates about legislation and regulation. And so that'll make more sense when we get to that point in the talk. So where I wanted to start is actually by looking back a little bit at the history of drug regulation. And fundamentally, when it comes down to it, there's a long history of attempting to use law to try to control access to certain kinds of substances, particularly intoxicating substances or substances that have some kind of medicinal impact. Prior to the early 20th century, most of those substances were pretty much unregulated. And so if you wanted opium or cocaine or alcohol or any other number of things, there certainly weren't regulations at the federal level. State and local governments would sometimes regulate these substances, but it was kind of very dependent on where you were in your local jurisdiction, whether they were regulated at all. Now, at the turn of the 20th century, there was a big movement, temperance movement, that successfully allowed for the enactment of alcohol prohibition constitutional amendment to the U.S. Constitution. And so beginning in 1920, 100 years ago, you were no longer permitted to buy or consume or own alcohol in this country for a period of 13 years. Now, Prohibition was actually a colossal failure. People who were intending to, at least the intent of the people who championed this approach was to say, if we ban this substance, people will stop using it, and then we won't have all the ills that come along with alcohol overuse. And as it turned out, it didn't stop people from using alcohol. It just meant that people purchased alcohol illegally, and a lot of the same problems continue to occur. Prohibition is largely seen as a failed experiment in terms of trying to control a substance. And the last thing I have on this slide really highlights that. Anytime we're thinking about how do we control the effects of something that's potentially harmful, might have potentially useful uses as well. But if we're talking about regulating something that's potentially harmful, there's always a debate that goes on about prohibition versus harm reduction. Do we try to prevent people from getting access to that thing altogether, whether it's a drug, whether it's alcohol, whether it's something else? Or do we try to allow people to have it but regulate it and try to mitigate whatever negative consequences there might be? And so, and as you'll see, I tend to be more in the harm reduction camp on these kinds of questions. But this has been a consistent theme in thinking about legal regulation over the years. And so you see, starting in 1938, there's the first federal law that regulates pharmaceutical products and other products as well. The Food, Drug, and Cosmetics Act of 1938 ends up regulating pharmaceuticals for the first time. There's a federal law that's passed in 1971 called the Controlled Substances Act, which is the law that leads to the creation of the different drug schedules. And the drug scheduling system is essentially a set of categories that determines when a drug can be sold, when it can be used, and for what purposes. And so Schedule I drugs are drugs that have a high possibility of dependency, but no recognized medical use. Now, among Schedule I drugs are heroin, marijuana, and some others as well. Now, of course, more recent information and research has pretty clearly shown that marijuana, for example, does have many potential medicinal uses, and yet it's still categorized as a Schedule I drug under federal law. Schedule II drugs are drugs that also have a high potential for dependency and can be dangerous, but have a recognized medical application as well. And so a lot of the opioid medications that have been prescribed over the past 2 decades that have at least contributed to the spike in opioid overdose deaths, a lot of those are classified as Schedule II drugs. They're approved by the FDA. They're sold for use to alleviate pain, but they also have the potential for dependency. And finally, another big part of the story, and one that I'm not going to focus on too much today, but it has to be acknowledged, is that the criminalization of illicit drug use, selecting certain drugs and saying that they're legal, and if you use them, you're subject to potentially very lengthy criminal penalties, is a big part of the story as well, because it greatly affects the consequences of drug use beyond just the effects of the drugs themselves. Okay, so at the same time, there has been this kind of pendulum swinging back and forth in terms of how pain treatment is regulated in this country. And so, just sort of a quick overview of the history of that. Starting in the 1950s, President Eisenhower crosses party lines and agrees with the Democrats in Congress to pass Social Security Disability Insurance, the first version of that, which was one of the first federal programs that allowed for access to care. Largely, this was designed to help people who had come back from World War II and also the Korean War, service members who were suffering from long-term pain from injuries they had received. And sometimes this was physical pain, sometimes it was psychological pain. But there was a great expansion in the use of both disability insurance sponsored by federal and state governments, and then also just innovations in the pharmaceutical industry for treatment of pain. So there's a great expansion between the 1950s and the 1980s. In the 1980s, there's a bit of a retrenchment during the Reagan administration. The Reagan administration really tried to kick people off of at least some of the federal programs that were supporting access to pain medication through the disability system. And then the pendulum swings back again in the 1990s, where you have a couple of things happening simultaneously. There's a big movement, advocacy movement, of patients and others who feel like they have inadequate access to pain medications. People who are in chronic pain due to a variety of health reasons successfully get the AMA and the Joint Commission on Accreditation, which accredits hospital systems, to change their policy on access to pain medication. And this leads to changes in federal and state regulations that allow for greater access and greater use of pain medication, including for things like palliative sedation and physician-assisted suicide. And you get Oregon being the first state to legalize physicians to assist in administering or giving patients access to what could be a terminal amount of pain medication if they have terminal disease and meet certain criteria. You also start to see around the same time opioid manufacturers, pharmaceutical companies developing stronger, more potent, more effective opioid medications to address pain, and embarking on what turns out to be a really aggressive marketing campaign for these medications, and trying to convince doctors that these medications can be marketed not only for the traditional uses, chronic pain or very serious painful illnesses like your chronic cancer diagnosis, and instead start using opioid medications for things that were less serious. You had your wisdom teeth pulled, you get a month of opioid medication, for example, things like that. And there was a really aggressive effort by these companies to market this. And what you see that this ends up leading to a huge spike in the number of prescription opioids being prescribed across the country, and this great expansion in opioid usage also leads to a great expansion in opioid dependency. Post 2008, after the recession, you see an even bigger spike, and that there are multiple causes for this, but economic insecurity, depression, and anxiety that go along with that, the so-called diseases of despair, have really exacerbated this situation as well across the population. You see there are what the data indicates very clearly is that you've seen this persistent increase over the last decade and a half or so. I already mentioned the aggressive marketing tactics. This gives you a little bit of sense of some of the data. So opioid prescriptions dispensed by U.S. pharmacies went up threefold between 1991 and 2011. There's a 500% increase since 2010 in the diagnosis of opioid use disorder, which are patients who have an opioid dependency and continue to use opioids even when they may not continue to have a prescription for them. There's a 700% increase in opioid-related overdose deaths since 1990, and that translates into an opioid overdose every 11 minutes in the United States. Now, what states started to do when these opioid overdose numbers started to go up significantly is states started to clamp down on access to prescription opioid medications. They realized that this trend had been significantly increasing. And so states put different restrictions on prescribing. States started monitoring prescribing much more closely. Physicians themselves started to be more reluctant to give people access to opioid prescriptions. But that didn't necessarily solve the problem. In fact, it may have made the problem worse, because as you can see, if you look at this data from the CDC here, and the trend over time, and this is just data for overdose deaths rates that are connected to opioid use. You see that up until between 1999 and 2009 or 10, you see that the increase is mostly from prescription opioids. That's the purple line. Post 2010, this is post recession, post states starting to clamp down a little bit on access. You start to see those other the brown line, which is heroin, and the black line, which is other synthetic opioids like fentanyl, start to become much more significant in causing overdose deaths. And this is a complicated story. There are lots of reasons why this might be the case. But I think one thing to keep in mind, and this is only part of the picture because this is only overdose deaths. It's not talking about just overuse and dependency more broadly, which is includes a lot more people than this. But what you see with this data is that what's driving the overdoses has shifted from prescription opioids to illicit opioids, and that's important because it also indicates where we should be targeting our efforts to try to decrease. And if we're trying to do harm reduction, and we're focusing a lot of energy on pursuing the opioid prescribers, that might not be the best place to put all of our efforts. So another part of the story, again, just to bring in another thread here, is the history of and implications of the tobacco litigation. So for those of you that aren't familiar with this, back in the 1990s, there was a successful settlement that was reached between states attorneys general. So these are the top lawyers in state government from 46 states, and the tobacco manufacturers. And this had been a long time coming. People have been suing tobacco companies for years, saying that they caused illnesses, and mostly it was individuals. Individuals were bringing claims against the tobacco companies, and they were saying, well, your product gave me lung cancer, or gave my family member lung cancer, and these suits all failed. The tobacco company was always able to defend themselves. They were always able to defend themselves by saying, well, you made a choice to use the product. We had a warning label starting in the late 1960s, and that's enough to insulate us from any kind of liability. The states came in and they tried a different theory. They said, well, this marketing of this dangerous product to people in our state has led to these huge increases in our healthcare costs. And we're paying for the healthcare ramifications of smoking. And it was a different legal theory that was harder for the tobacco companies to defend against. And ultimately, the suit didn't go to trial, but there was this master settlement agreement reached in 1998, which guaranteed the states over $200 billion over the course of the next 25 years. And so we're approaching the end of that 25-year timeline. But states have been receiving money for years now from this tobacco settlement. So ultimately that's a great thing. But there are a couple of lessons learned from this tobacco settlement as it applies to states that are currently trying to do the same thing with the opioid companies, right? So one lesson learned was that the settlement money didn't necessarily go where everyone expected it to. Everyone thought, oh, this money's going to go to public health programs, it's going to go to tobacco cessation programs, it's going to actually help people with their medical bills, or it'll help stop people from starting smoking in the first place. And some of the money did go to those things, but the vast majority of the money didn't go to any of that. Most of the money just came into the state budgets in these different states, and the states used it for whatever they wanted to. It just became it went to the state's general fund, and they said, oh, we're going to pave roads, or cut taxes, or do whatever we want to do. And so it was just an additional resource for the states, and they didn't necessarily use it for the purposes that the settlement seemed to intended to be used for. And that wasn't true across the board. There were some states that did use it for those purposes. Another thing that came out of this in retrospect is that the states kept the money, and other entities like local governments, for example, that were also affected by these health costs, they didn't get anything out of this at all. And so, and this is relevant because in the current suits that are going on against the pharmaceutical companies, against the opioid manufacturers, the local governments aren't relying on the state governments to bring the lawsuits for them. They're bringing separate claims on their own, in part because in this last big litigation, they were completely cut out of any sort of proceeds. And this creates a very interesting dynamic between state governments and local governments. In addition, the other thing that is relevant to the current litigation is that one of the other effects of the tobacco settlement in the late 90s was it brought a huge amount of attention to what the tobacco companies are really doing. And even though it was pretty widely known that tobacco use was harmful to health. It really wasn't until this litigation commenced that you started to see huge public releases of documents that were gained through discovery. Discovery is the process in a trial where the opposing parties have to disclose information to each other. And so this information ends up going into the public record about all the things that tobacco companies did to try to manipulate people to use their products and to try to encourage them to do all these aggressive marketing tactics and all of the information they were hiding about the dangers of the product. This all came out, and a lot of that really changed the perception of tobacco use. And so, we've seen a huge decrease, at least in traditional tobacco use, in cigarettes, cigars, smoking, over the last 20 years. And a big part of that is because so much of this information came to light and was available to the public. And so, one of the things that is at issue right now with the opioid litigation, some of the information has come out, but at least in all the pending suits, the courts are keeping everything under seal right now. And it's unclear whether this information is going to be disclosed to the public. If it is disclosed to the public, I think it'll be really useful to help people understand what's been going on, what these companies have been doing for a lot of years. Okay, so now, if you combine all of these things together, right, and you have this spike in opioid-related dependency that's been going on for the last decade and a half or so, and you have states and local governments and even the federal government trying to intervene in different ways to try to stop this increase in opioid dependency and overdose deaths. You also have simultaneously these pharmaceutical companies with their aggressive marketing tactics. You have the knowledge of what happened in the tobacco litigation 20 years ago, and you have also sophisticated attorneys who understand that and are actually trying to help the local governments bring cases on their own. You get the situation that we have right now, which is you have thousands of cases that are pending in different courts around the country against the opioid manufacturers with all sorts of different legal theories trying to hold them liable for the costs that they've imposed on individuals, on local governments, on state governments, and some others as well. So I'm going to try to break this down as clearly as I can, but it's hard to do that because it's actually really complicated what's going on right now. So what started out is that back in about 2003 or 2004, you start to see the first lawsuits against the opioid manufacturers for claims that they marketed defective products, they were negligent in allowing these products to be on the market, that their marketing tactics were fraudulent, and some other legal theories as well. And a lot of these original cases were just brought by individuals, people who had become dependent on opioids because of their exposure to these medications, and believed that it was the fault of the manufacturers that they ended up dependent, or in some cases having opioid overdoses, and in some cases it was the families of these people who had died from opioid overdoses. And then there was a separate set of cases that were brought by state attorneys general on behalf of states for the same kinds of theories that we were talking about in the tobacco litigation. That the state medical costs were going up to have to take care of all the people who were affected by these by opioid dependency, right? And so those initial set of cases were not successful at all. And in fact, the manufacturers won almost every single one of those cases. And their successful argument that defending themselves was it was similar to the early tobacco litigation. They said, basically, you can't hold us accountable for this because, yes, we might have been kind of aggressive in our marketing tactics, but ultimately it was the physicians and the patients who made the decision to, physicians made the decision to prescribe, the patients made the decision to take the medication. The fact that they later became dependent or overdosed because of excess use of the medication, that's their responsibility. There was an intervening decision that was made, and so you can't put that on us. Now, in tort law, that argument can be made and can be successful, but it's not always going to be successful. And in fact, there's no reason that just because someone else made a voluntary decision, it doesn't mean that your behavior was reasonable or that it wasn't fraudulent or wasn't negligent. And so there was an early settlement, though. Some of the state claims that were pending in front of courts in 2007, Purdue Pharma, which is one of the big opioid manufacturers, they make OxyContin, They settled with 26 states on some fraud claims and violations of the Controlled Substances Act claims. And they gave these states about $600 million. At that point, they also started changing some of their marketing tactics because they realized it exposed them to liability. And more recently, starting in about 2013, there was this whole separate set of litigation that was filed. And again, it was states. It was, and this is where the local governments start to get involved. So you start seeing local governments realizing that they're facing medical costs, they're facing other kinds of expenditures to care for people who are affected by opioid use. I showed you that chart before with the huge spike post-2010. A lot of that doesn't have to do with the prescriptions, although many of the people that are now using illicit opioid sources like heroin or fentanyl, illicit fentanyl at least, were people who, at least some of those people were people who became dependent on opioids through prescriptions initially, and then once they were unable to get further prescription opioids, turned to the illicit opioids. Some people are just using illicit opioids just to treat their pain because they can't get access to the prescription opioids in the first place. And so the huge increase is still a big issue. The states and local governments are trying to now go back and say, manufacturers, you're the root source of all of these troubles that we're having, and you should be paying for that because of your fraudulent and negligent activities. And so what you have now is, and I'll show you some numbers here. There are 48 states have filed some kind of lawsuit against some set of defendants, including opioid manufacturers, including distributors, so people who actually distribute the medications, against pharmacies as well, and so people who are actually dispensing them to patients, and also there's even a lawsuit against the accrediting body that accredits hospitals for encouraging them to use these medications. And so there's all sorts of different legal theories out there. There's also over 2,600 local jurisdictions that have filed claims. Now, I'm going to get a little bit technical for a minute in terms of the sort of procedural stuff in the lawsuit. So, or these lawsuits. States have typically filed their cases in state court because usually a state attorney general is going to file a case within the courts of that state, and so bringing claims under state law and in state courts. The local jurisdictions, for the most part, are bringing their cases in federal court. They're suing defendants that are out of state, and so the claims that they're bringing are being heard in federal court. And so you have two different systems that are progressing simultaneously. What has happened is there were so many of these lawsuits from these local governments that were being brought, and in part there were so many because they were actually attorneys who had expertise in this kind of litigation, going around to local governments and saying, we're going to, we can represent you, you should be part of this, and you've actually suffered harm, and we can actually represent you, and we'll handle all of the legwork, you just need to join the suit. So there suddenly were this huge number of jurisdictions involved, and so what happened is there was a multi-district litigation, which is, I'm going to find the slide, is when it's a procedural option that can happen in federal court where all of these cases are consolidated under one court. And so they basically take all of the lawsuits that are filed all in federal courts all around the country, they put them together in one court. In this case, it's the Northern District of Ohio. And Judge Polster, who is a district court judge in the Northern District of Ohio, is overseeing all of these cases. And multi-district litigation is not a class action. So for those of you that have heard of a class action lawsuit, your class action, you need to show that all of the parties to the case share certain similar characteristics. And there's so many differences in the damages and the details among all of these different plaintiffs in these cases that they couldn't do a class action. But they are doing what's called multi-district litigation, which basically is a way to get all of these parties to settle. Because there's no way you can do thousands and thousands of distinct lawsuits. They've never addressed, and the first parties to win would essentially get all the money, and the rest of them would be out of luck. This approach is designed to sort of coordinate everything. And so you can say, well, we're going to, so kind of like that master settlement agreement with the states that happened with the tobacco companies in the 1990s, you could get all of these thousands of local jurisdictions together and say, we're going to come to an agreement between you and all the people you're suing as to what the fair amount will be. You don't have to go through a trial for each one of these counties, each one of these cities. We can come to a resolution and resolve it right here. And so, of course, that's fantastically complicated because you have to get both sides to agree, and you have to get all these different parties to agree. One of the things that Judge Polster tried to do was to say, because there's so many counties affected by this, and this is only a small subset, we should actually apply this to all 33,000 local jurisdictions in the United States. And we're going to just kind of join them into the suit. Now, no one's ever tried to do this before. And so there were lots of objections to this idea. There were lots of people who said, we can't do this. The state attorneys general said, we don't want you to do this either, because they're thinking, well, this is the same money that we're going after from these defendants, right? And so you have this weird conflict that was created between the state and local governments. And what you start to see is see some states, their state attorneys general starting to try to take over the local cases, to say, we have the authority to take over your case, and the state should be the entity. So the Ohio Attorney General argued that state legislatures and attorneys general are best situated to ensure the money goes to where the harm is. And so a couple of states have tried to legally intervene to take over the local cases. They haven't been successful so far, but they're trying to do this. And what it reminded me of when I was looking at that situation, it reminded me of something that goes on often in the legislative context between state and local governments. So, and this happens a lot, especially in public health. So, oftentimes the local government will want to do something to protect the health of its citizens in its local jurisdiction, and the state doesn't want the local government to do that for a variety of reasons. It might be because the state government has a sort of different priority than the local government does. The state government's trying to protect the revenues of businesses, and the local government's trying to protect health. And so you get situations where, in a number of states, local governments have tried to ban fracking, or they've tried to ban non-reusable plastic bags, or other things like that, or sodas over a certain size, sugar-sweetened beverages over a certain size. And state governments have come in and actually passed legislation to preempt that, to say, local governments, you're not allowed to do that. And this, it's not exactly the same thing going on here, but it's a variation on that. So here you have states saying, we know you're pursuing these damages for damages to people in your local areas. We want to subsume those cases into our state cases, so we essentially get to say who gets the resources when we have a settlement or when we win a judgment in the end. And in fact, in the one state so far that actually has a legal judgment against one of these opioid manufacturers, it's the state of Oklahoma. It happened last year. There was a judgment, $572 million against one of the opioid manufacturers. And the judgment actually, but before there was a final ruling, they came to a settlement agreement between the manufacturer and, in this case, the state of Oklahoma, and they said, we're going to use this money in part to cover healthcare costs. We're going to use this money in part to fund a new academic center at one of the universities in the state to study opioid use. And the state government, and even though this was negotiated by the Attorney General, the legislature then jumped in and said, all future settlements need to go to the state general fund so we can decide how to, because they were upset that the money got allocated toward a specific project. And so we're going to increase it. So this is what's down the road. We're going to increasingly see fights between state governments, local governments over the disbursement of these settlement funds, if the settlement actually can be negotiated. And that's still a big if. So, I found that there was a cartoon in a Ohio newspaper sort of insinuating that the state attorney general was trying to, steal funds from the local lawsuits. Now, of course, things have not really gotten that far yet. Anyway, so you have this preemption concern and this effort by states to take over what local governments are doing. You also, at the same time, have an issue with privatization. So the last thing that I have listed on the slide here is kind of the second point of conflict between state and local governments. The state governments, for the most part, are represented by their publicly elected attorneys general. The local governments, for the most part, are represented by private attorneys. The reason for this is because most local governments don't have the resources to fund their own case. They don't have the expertise to fund their own case. And so private attorneys have taken these cases. This is not uncommon. This happens a lot. But because the private attorneys are heading up the local cases, they've managed to, first of all, consolidate a lot of cases under the same attorneys, which makes it more efficient. But it also means that these attorneys are working on contingency fees, which often happens for large lawsuits like this. So the attorneys don't get paid until the suit is resolved. And if the suit is resolved with no damages being awarded, the attorneys don't get anything at all. If it turns out that the suit results in a damage award or a settlement award, the attorneys take a percentage of that settlement. So oftentimes it's going to be a fairly large percentage. It could be like 25 or 30%. And so what some of the state governments are saying is, we don't think it's appropriate for private attorneys to get 25% of a damage award that is awarded in these cases for purposes of trying to address the opioid epidemic. And so they're trying to intervene proactively and say, we're going to either cap the amount of damages that attorneys can get for representing the local governments in these cases, or we're going to say that they can get very little at all, or we're going to say that local governments can't use private attorneys for these kinds of things, that they have to either do it with their in-house counsel or not at all. They can't participate. And so these kinds of disputes are also kind of winding their way through the courts right now. And how it turns out is really indeterminate at this point. So let's see. I guess there are a couple more things, and then I'll stop and we can have questions and discussion. I want to give you a sense of what's been going on now. So these cases that have been consolidated in front of the court in Ohio, all those local government cases are currently pending, and at the moment everything is kind of stalled because at the same time that all this is going on, you have these state cases, you have these local cases that have been consolidated in the multi-district litigation. You also have bankruptcy proceedings going on for some of the major manufacturers. So Purdue Pharma, which is the biggest opioid manufacturer, filed for bankruptcy back in September. And so there's a separate legal process that goes along with bankruptcy. And so the bankruptcy court, among other things, they try to prevent the assets of the bankrupt organization from being pulled away until its obligations are met through the bankruptcy process. They decide how to allocate those resources. And so while initially there was an expectation that Purdue Pharma would agree to something like a $12 to $15 billion, or no, $10 to $12 billion settlement, that was the proposal. The bankruptcy judge says, well, at this point, we need to work through the bankruptcy first before we can allow any of that money to go anywhere, to any other judgments. And so all of these lawsuits that have been pending are kind of stopped right now. The bankruptcy judge has stopped them in their tracks for the moment. So we'll see what ends up happening with that. Also, at the same time, there's some criminal prosecutions going on. And so there are some states that are, under state law, criminally prosecuting executives of some of these pharmaceutical companies. And so far, most of these cases have not come to fruition, except just last week there was the first verdict against one of these executives from a pharmaceutical company, John Kapoor, who was the founder of a company called Insys Therapeutics, was one of the opioid manufacturing companies, was found guilty of bribery and other charges, saying that that their company was bribing doctors so they would prescribe more opioid medications, and they were able to prove this in court, and he was sentenced to a 5-year prison sentence. And that just happened last week. So, and there are other pending cases like this going on, and so it's unclear whether those will have the same result, but they're still going forward. the final thing is that they're trying to, there are other defendants here. So it's not just the pharmaceutical manufacturers, it's also these distributors and pharmacies and other parties are involved. And so some of the distributors were proposing a settlement for $18 billion. That's still pending as well. So all of this is really in flux right now. So with all of that being said, and this is sort of this is the last thing I'll talk about, and it's kind of the critique of the whole situation, right? We have this major public health problem. Ongoing major public health problem. And obviously litigation can have some really beneficial effects. It can give people redress for harm they've already suffered. It can give states and local governments the possibility to have access to resources that they can use prospectively to try to intervene and hopefully reduce the public health impact of these situations. At the same time, though, as you can tell from just the little bit of this that I've talked about today, it's incredibly complex what's going on. Trying to come to an appropriate resolution that actually gives these injured parties the amount that they really need to cover their losses and to help them change what's going on in their communities. It's very unlikely that these companies have the resources to do that. It's very unlikely that it's going to happen anytime soon. And so as a result, oftentimes the litigation gets a lot of attention, but isn't really if you were going to try to design a way to solve these problems, this is not the way to do it. Litigation is often retrospective. It's always retrospective. You're talking about something that's going on, that's already happened, past behavior. Much of that behavior has already changed, but it's still appropriate to hold people responsible for that past behavior. Actually, using this process to get the resources that are necessary to address the problem, though, it's only going to be a part of it, and it's going to happen much later than you need it. And so, really, the way to more effectively solve this problem is to not rely on the litigation and to put more resources into getting legislation and other allocation of resources from governments and other places prospectively to try to address the problem. And finally, I think that it's important to note that as we see this overdose epidemic continuing to persist over time and continuing to grow over time, it's not just opioids that we need to be paying attention to. And this is really important as well. That many of the overdose cases are not just people who have an opioid dependency, but are people who have polysubstance use issues. So in other words, it's not just opioid medications or opioid drugs. It's also alcohol and methamphetamine and other things as well. And if we really want to solve these problems, we need to identify the larger problems in our society that are driving the widespread use of these substances. Why do people feel the need to dull their pain? Well, what else is going on in our society that's driving these bigger trends, and what can we do to stop that? And obviously it's a hard question to answer, but I think it's worth us thinking about when we're thinking about this problem. It's not an isolated problem, it's part of a much bigger concern in our society. So I'm going to stop there and look forward to your questions. Yes?
What happened with the Sackler family? You had that on?
Oh, yeah. So the Sackler family, for those of you who don't know, they're the family that owned Purdue Pharma. They, among other things, there are some criminal charges against members of that family for kind of spearheading these aggressive marketing tactics over the years. Those charges are still pending in several states. I know Massachusetts there's a large case in Massachusetts against them. I think also in New York they're being prosecuted as well. One of the big issues with the Sackler family is that, as part of the settlement negotiations and even the bankruptcy, trying to figure out how much money the company has that could be disgorged and given to plaintiffs in this case. The family itself has taken a lot of money out of the company and put it in bank accounts in other countries and things like that. And so there's a question as to whether, how you count the assets of the company. Does it include the family's assets or just the kind of formal assets of the company? And so that's another thing that's being kind of fought out in the courts right now is, what's the what's the available amount of money that's there. Now, the Sackler family is another interesting part of the story is that they've been very prominent as philanthropists, and they've given a lot of money to lots of museums and other nonprofit causes and things like that. And so a lot of there's been a big push to these institutions to take the Sackler's name off of these things that they funded because they're connected to these activities. Ultimately, there's actually a really good article that kind of goes through the whole history of like how this family has been very integral to the growth and use of opioids, and I think it was in the New Yorker about a year ago or so. A really good article that kind of summarizes this pretty well. But I think it's interesting to see prosecutors going after individuals. That's not something that historically has happened a lot in these kinds of cases. But now there's a precedent, and so I think it could be, we could see in the next year or two some further prosecutions of the actual owners of some of these companies as well. But that still remains to be seen. Yes?
Professor Gabe, do you have any documentation about China and Russia trying to flood the United States with super synthetic opioids through these phony companies that have been set up in the United States?
I don't know. I've seen, I know I've read about efforts to try to prevent, especially from China, fentanyl that was being manufactured there en masse and being kind of imported into the United States. And I know there's been some journalism and some media reports around those efforts. I don't know if I don't know if there's any pending litigation, or if there are any efforts to hold specific individuals accountable for that kind of effort. Now, obviously, there's a big apparatus to try to prevent importation of illicit drugs, and in this case, I know there's been some diplomatic efforts as well to try to get the Chinese government to crack down on some of these manufacturers. I don't know how successful that's been, and honestly, right now the relations between the U.S. and China are complicated, to say the least.
Very complicated.
And even beyond that, I mean, with the coronavirus outbreak going on right now, that's going to also further challenge not only the relationship between the countries, but also just trade and travel and movement between different parts of the world. So, but I'm glad you raised that, because among the strategies that can be pursued, is to try to reduce the supply of illicit substances, including fentanyl. We know that a lot of that has been manufactured in China, and I think that I know there are a lot of efforts to try to stop that. That being said, we also know from 50 years of trying to stop illicit drugs coming into the country that usually if you stop one source, another source will spring up somewhere else. And so I don't know ultimately if that strategy is an effective strategy, but it's certainly one that I know is being pursued.
Thank you.
Yes?
You talked about local and state governments taking steps to either sue or litigating this issue. Has this federal government taken a stand or done anything relative to what the other governments are doing? And then is this process impacting policy related to hopefully moving toward harm reduction?
Okay, so on the first question, is the federal government doing anything? The federal government is not involved in the litigation in any way. They are, this is being driven by state and local governments, but the federal government is doing things related to bigger picture policy issues. There's been some funding that's been approved by Congress and signed by the president. It's minimal. It's not nearly enough to do very much of anything. And in fact, trying to think of how best to characterize this. The Trump administration declared a public health emergency related to the opioid overdose crisis about 2 years ago, and with a lot of fanfare. But then that hasn't really resulted in much actual activity from the federal government. aside from ongoing programs that had been in place prior to that. And in fact, I think it's an indication of how seriously the administration is taking it, that the public health emergencies are, they're temporary, they're time limited, and you have to renew them every so often. I think it's every 6 months. And so when this last 6-month period passed, the Department of Health and Human Services forgot to renew the public health emergency for the opioid crisis. And in fact, it didn't get renewed until a reporter asked the Secretary of HHS, why haven't you renewed this declaration? And then they did it the next day, but I think they literally just forgot about it. So, at least at the high policy levels, even though there's some lip service, I don't know that much is going on. Now, that being said, there are lots of people in the federal government who are working in different departments, particularly in health and human services, who are involved in programs that are designed at supporting harm reduction efforts. There's a lot of stuff going on at state and local levels as well. There's a lot of stuff outside of government. I mean, there are a lot of advocates who are really trying to push legislators at the federal and state level to recognize that resources are needed for these approaches. One of the really big, talking about harm reduction, one of the really big struggles right now is that one of the responses that some states have had to trying to stop opioid overdoses is to impose harsher penalties on people who are at the scene of an overdose, and that's really counterproductive. So you have people being prosecuted for homicide, for essentially sharing drugs with a friend, and that friend ends up dying of an overdose. And so what that does is it prevents people from calling for assistance when rapid assistance could have saved someone. There are some states that say, oh, well, you get one freebie. If you call once, we're not going to prosecute you. But if you call again within a certain amount of time, we will. And so that's a really terrible incentive. Wow. And not only is that harmful in terms of deterring people from calling for help when people they're with need help, it also is just it's the absolutely wrong approach to try to reduce harm. If you're trying to reduce harm, you want people to feel safe and comfortable calling for help when help is needed. You want people to be able to carry, for example, sterile injecting equipment if they're an injecting drug user, and not be prosecuted for that. There's a really interesting case going on right now. There's a facility that just opened up in Philadelphia called Safe House, which is it's a safe drug consumption facility. It's the first one in the United States, and the federal government and the federal prosecutors are trying to shut it down, saying that it violates certain drug statutes of encouraging drug use. They've successfully opened the facility. They won the first round in court, basically saying that they're not in violation of the statute. That's being appealed, and who knows what's going to happen with that. If we were really being serious about harm reduction, that would be a widespread approach, because not only does it allow people to use drugs in a safe setting, if they actually need help, they can get it immediately. And in other countries where these approaches have been used, it's been really successful. Not only that, but you also can use that site to connect people with rehabilitation kind of services to help them get off of their dependency of these substances. So I think that ultimately that's a good strategy, but it's not legal in most states. So that's going to be another set of issues going on. Yes?
I guess would be two questions. And I guess my first question is related to where does the money go kind of thing. I remember the time when the cigarette companies were exporting all their cigarettes out to other countries. We always worry about what's coming in here, but we tend to take all our problems and send them abroad. So it's kind of like it's an interesting sort of xenophobic response. But my other question has, there's a lot of stuff in the media about big pharma and all that sort of thing, and where the data is coming from and who is doing what to whom. I'm kind of wondering that, and then I think of the depression being a big issue along with the opioid crisis, of antidepressants, and the drugs list just seems to get longer. So is there like an overall strategy that is being used? Or is this sort of like, right now this is our current crisis and we don't see those bigger ones coming down the pike?
Okay, so I'll try to answer the second one first, which is, I mean, there is no bigger picture strategy. I mean, there are definitely people who have been looking at these issues from a bigger lens and are trying to get a grasp on the things that are coming in the future, either with other kinds of pharmaceutical products or you know, other products that are harmful to health. But as we've seen, you know, to go back to the backup example, as we've seen very recently, people are very short-sighted when a new product comes on the market. So, you know, I was talking about the huge reduction in tobacco use from cigarettes and cigars, but we've seen a huge increase in tobacco use from e-cigarettes and vaping. And that's basically because those products weren't regulated, and even though people in the public health world were saying, you know, we should be paying more attention to this and thinking about how this is going to affect health down the road, it wasn't really until recently when there were some kind of high-profile, very obvious health effects for certain users of e-cigarettes that there started to be this flurry of attempt to regulate those products. And all that being said, you know, I think that, you know, in an ideal world, we would be thinking big picture and thinking about, and you know, I was saying before that, you know, a lot of these overdoses are not purely based on opioid use. They're based on, you know, polydrug dependency. So you have people who use a number of substances, sometimes together, sometimes in, you know, at different times, and you know, it's, you know, that problem is not easily addressed by going after one set of manufacturers or by even by, you know, having a particular set of regulations. You know, a lot of those trends are being driven by underlying social factors, including poverty and depression and anxiety and other kinds of insecurity. And so those are issues that we have to really be thinking about, big picture, and that will help with these problems, but that will help with other problems as well in our society. So, I think I saw hands back there, yeah.
Forgive me if you touched on this in the beginning of your presentation, but I know it talks about the opioid crisis. There's more conversations about physicians and medical practitioners being somewhat like sponsored by some of these drug companies. And I guess when we think about like settlements and cases that are coming up like in courts, are some of these like malpractice suits possibly more I guess effective or successful than possibly suing the pharmaceutical companies themselves? Like what's happening with the doctors as well?
Yeah, this is a great question. So some of the early cases related to this situation were cases against individual physicians for prescribing, inappropriately prescribing opioid medications for things that they shouldn't have been prescribed for. Most of those cases, in fact, I think all of those cases were unsuccessful. And the reason why is that physicians are given quite a lot of discretion. And so, you know, if the physician was actually taking like a kickback from the company, that's one thing, and that wouldn't be a malpractice claim. It would be more of a, you know, a fraud, or, you know, there could be some other legal theories that could capture that. Most of the current cases are against the larger entities, like the manufacturers and the distributors. I think that's largely because they also have deeper pockets as well, and these cases are being brought for the most part by governments and not necessarily by individuals. I'm sure there are still some individual suits out there, but they're a very small part of the bigger picture here. Now, all that being said, you know, could you successfully make that kind of case? I think with the right facts, you might be able to. I mean, I think that is a possibility, but I haven't seen very many of those cases. Yes?
I just actually have a comment. First, so I have something called Factor V Leiden, and I touched upon this last week. So, I mean, God forbid, like, if I need surgery or something, like, I can't have, like, Motrin or something. So, it would have to be Tylenol or a narcotic.
Yeah.
So, since this is going on, like, if I were at the doctor, like, they would be like, well, we don't prescribe this anymore because we've been sued. Like, how would my pain be? managed. I'm not asking you to answer that. And also other countries, developed countries like France, the UK, Germany, whatever, they don't have this opioid problem. And it's kind of like, where is the blame at for the public in general? I mean, I'm not saying that these pharmaceutical companies are off the hook, but it's kind of like, okay, well, what about the rest of the world? Like, they don't have this problem, and I'm quite sure they have, like, overseas divisions where they're manufacturing this product in other countries, like Australia and stuff. So it's like, as a society, like, where does the public come in to be blamed for this as well? Like, I'm addicted because you advocated this. I know people who have chronic pain and they take these medications successfully and haven't gotten addicted. So it's like a double-edged sword here.
Yeah, no, I think those are both really important comments because on the first point, I mean, I was talking at the beginning about sort of this pendulum swing back and forth of how we regulate access to pain medication. After the past 2 decades where we sort of went through a phase where there was a huge amount of accessibility to pain medication, in particular opioid medications, but others as well. The backlash now with what has happened with so many people becoming dependent on opioids and having all of these overdoses. The backlash now is exactly what you're saying. Is that either directly through regulation, states are clamping down on how these medications can be prescribed, or they're just putting so much scrutiny on physicians that physicians are becoming a lot less willing to prescribe these medications. And that actually has real effects, and it can be really detrimental to people who are in real pain and need access to these medications. So you're going to have a lot of people who are suffering and not able to get the medication they need as a result of some of these approaches as well. And so that's the other side of the equation, and we can't forget about that. That's really important. We need to make sure these medications are very effective at reducing pain, and how do we allow people to benefit from that effective treatment while also trying to prevent some of the negative dependency kinds of problems, and that's I don't have a good answer, obviously, to how to balance that. But I think that's important to keep in mind. I mean, it's really important. And your other point, I think, is really perceptive too. I mean, we've had a much larger problem with dependency and overdose in this country than any other developed country has had.
Yeah.
And
they have those.
I mean, why is that? What is it about our society that's more conducive to this happening? And whether it's and I think there are many possible answers to that. I don't know which are correct. And it's probably a combination. But I think that's actually probably a good place for us to end. I mean, these are big societal problems that we have to really address at a population level. And piecemeal approaches can make some progress, but they're not going to address the big picture. It's something that we really have to assess and understand and try to think about in a very broad societal kind of way. Yes, do you have a final comment? Okay.
I was wondering about back in World War II, at the end of it, they had, many of the soldiers had severe war injuries, and they were prescribed morphine, which is at the class 2.
Yeah, morphine would be schedule 2, yeah.
And many of them, probably might have become addicted to it because it is such a strong, painkiller. But they then automatically become drug addicts, like people have, like which they're afraid of now. If they, like what she's possibly referring to, if you give people that, a strong pain medication, that you're inducing the possibility that they will become addicted to it. And I was just wondering, back then, they didn't become drug addicts. Did they just make them go off of it cold, withdraw it slowly from them, or what?
I actually don't know historically. I mean, I'm not sure if there was less dependency that occurred during that time frame, or maybe it wasn't tracked as carefully, and maybe it happened at similar rates, but we just weren't as aware of it. And maybe once the medication was withdrawn, there weren't other sources as revenue. And so a lot of what happens, now is that when people lose access to a prescription form of these medications, there are other options. That in part explains the huge increase in overdoses related to heroin and fentanyl. I mean, fentanyl, because it's a stronger substance in terms of its effect on the human body, and because it's more frequently now mixed together with heroin. People who were seeking heroin might be getting more fentanyl, and that also has been driving some of those numbers. And so, part of the overall ultimate strategy has to be thinking about, what's the right balance of access to, sort of legally authorized prescription medication people can use for pain, or people can use to appropriately and safely withdraw from a dependency, because that can take a very long time if you're doing it sort of with best practices. And so giving people access to buprenorphine, which is a medication that can be used to reduce and eliminate dependency over time, instead of having that person, satisfy their dependency by going in and finding heroin or fentanyl from a source that, not sure what the strength of that source is, and could lead to overdose or other harm. And so, ultimately, I think, I don't know what was different in the past. I think those are some of the factors why, but I think that's, going forward, we need to think about policies that are going to allow us to strike that right balance between the two things.
Okay, thank you so much.
Thank you.